Hi, I'd like to welcome everyone to the HKU CCPL book talk for Constitutionalism in Context. I'm David Law. I'm the E. James Kelly Jr. Research Professor of Law at the University of Virginia and Courtesy Professor of Politics. And also, I'm very honored to say Honorary Professor of Law at Hong Kong University, where I served for 5 years. Some of you may recall me as the having had the Sir Y.K. Pao Chair in Public Law. It was during that time, one of the best times of my life, personally and professionally. I got to know both of my co-presenters today, Professor Albert Chen, the very distinguished Albert Chen of the University of Hong Kong, my former colleague, and Mara Malagodi, Dr. Malagodi. Again, a great pleasure and privilege to get to know her at Chinese University of Hong Kong, the law faculty there. The format for today's presentation, both of them, Albert and Mara, are contributors to this volume, Constitutionalism in Context, which is the focus of our panel today. There will be a Q&A at the opportunity for questions at the end of the talk today. And it's an extreme pleasure of mine also to be able to do this talk via the Center for Comparative and Public Law, given that this is a book that had its inception at a conference in HKU and was developed with support from both internal HKU grants and a general research fund grant from the Hong Kong government. So without further ado, the format here is I will speak for about 15 to 20 minutes introducing the book, the idea behind the book, and launching into why this book places so much emphasis on Asia and why we as a field in comparative constitutional law should be paying more attention to Asia. Taiwan will be the example I will use as an example of extremes in judicial power. Professor Chen will be using China as an example of extremes in the concepts of constitution and constitutionalism. And Dr. Malagodi will be using Nepal as an example of the extremes of conflict that international law and constitutional law can come into when they collide. Okay, so with that in mind, let me share my screen with you. Let's see here. Here we go. Let's see. This should be okay. All right, so this is a, excuse me. There are some versions there are different ways of doing comparative constitutional law. And this book tries to take on a slightly different approach to the subject. Sorry, just trying to, excuse me. I just have to share the screen here. Try to do this again. Okay. So we can think of there being as being 5 potential approaches to the study of comparative constitutional law that may be implicit, if not explicit, in the field. We could call these instrumentalism, tourism, immersion, and abstraction. And a 5th, which is not really that commonly seen, but we could call it the representation approach, all right? Some of these, the first 4 hopefully will sound familiar. The first 2 are quite common in comparative constitutional law teaching, and the last 2 are more common in scholarship. Okay, so first, instrumentalism. This is the idea that one goes around the world looking for the most useful things, skimming the cream off the top, right? And leaving everything else. So if you are an instrumentalist, that means that you are looking at other jurisdictions around the world, trying to find things that will be useful to you as a lawyer, say high profile cases on hot button issues in your home country. You're not necessarily interested in learning how locals see things or what the locals care about or what the issues that are most important to people there are. You're interested in what they have to offer you, okay? And so there's a kind of teaching material and a kind of scholarship that goes along with that, which is high-profile cases from countries with active traditions of judicial review and cases that you can feed into your own legal briefs, right? That would be an example of this kind of approach. Another approach would be what we might call tourism. The idea here is what are the most famous or the biggest cases, the highlights. These could be the things that are most popular for other people to see. They could be the things that are in some sense best or canonical. But either way, it's kind of the equivalent of if you go to Europe and you're on a bus tour, there are certain things you're expected to see, like Big Ben and the Eiffel Tower. The analogous approach in comparative constitutional law is if you are taking the tourist approach, of course, you're going to study certain key cases from South Africa, such as the Grootboom case and the Makwanyani case on the death penalty. And if you're going to study Canada, and you'll check out the secession reference, of course, and the Oakes test. And Israel and Germany all have their greatest hit cases. It's the equivalent of this kind of a tourism approach. All right. A third approach is we might call this immersion. This is a picture of a Balinese cockfight, right, with a nod to Clifford Geertz here. The idea here is it's almost anthropological or ethnographic. You aren't trying to just extract the things that are useful to you as a lawyer. You're also not interested in just seeing the greatest hits or what other people are interested in seeing or tell you is the most popular or the best or the greatest. You're interested in actually really understanding and seeing through the eyes of the other. So if you're studying France, you want to see the world through how a French lawyer sees them. If you're studying Bali, you want to see the world through the eyes of a Balinese lawyer, so on and so forth. And there's a rich tradition of this, certainly in comparative constitutional scholarship. These rich case studies, small and single country or two country case studies, often just one country. And that has a long scholarly tradition. The exact opposite of that, which also has a lot of traction in the scholarly world, is what we might call abstraction. And this is zooming way out, not just the bird's eye view, but the satellite's eye view, right? From such a distance, we begin to see patterns and groupings that might not be obvious if you were looking very closely. And in comparative law scholarship, there have long been impulses toward categorizing, classifying, identifying legal families, generalizing, and also splitting things into larger categories, right? And so that's a familiar type of scholarship. It can also be used as a teaching approach, right? Start with the common law and the civil law, then problematize the common law, split the civil law into component families like the Scandinavian family, the French family, the Germanic family, and so on and so forth, right? A fifth approach we don't see as often is what we might call the representation approach. And here the idea is to highlight the diversity of constitutionalism around the world, to expose people to as broad a range of variation as possible. So the slide here, the representative image is, I don't know if anyone can guess what that is. If you want to guess, you can put your guess in the Q&A. But if you haven't got time for that, this is the Metropolitan Museum of Art in New York. And the reason I put the Met up here is we can think of the challenge that a museum curator faces. So museums can typically only show about 2% of their collections at any given time. And so then the question becomes, what do they show you? And to some extent, of course, if they have things that people really want to see, they'll 2 or 3, marquee objects, they might put those out. But for the most part, they're trying to convey a sense of the overall collection, right? They're not just going to show you just the Expressionists, right? Or just the sculpture collection or just the Egyptian collection. They want to give you a taste of everything in the collection. And we could take a similar approach to the study of comparative constitutional law, right? So if we, this volume, Constitutionalism and Context, tries to take that representation approach. It tries to sample a bit of everything. It tries to be representative of constitutional variation around the world. It tries to be representative of the diversity that in fact exists. And if one is being representative of comparative constitutional law around the world, one consequence of that is we would put much greater emphasis on Asia than we as a field currently do. More than half the world's population is in Asia. right? And it's not just population, there's a rich amount of constitutional experience to be sampled. One wouldn't necessarily know that from the existing literature and a lot of the existing reference and teaching books. But this book really tries to be representative in the sense that over half the population is Asian. We would argue that over half of the wealth of constitutional experience it follows is also to be found in Asia. And over half of the book, well, fully half of the book is drawn from Asia. And some of these countries have a tremendous amount to offer, and that hasn't really been recognized much in the field. I will start with the example of Taiwan. Taiwan is a case study in extremes of judicial power. Many of you may be familiar with this debate in the literature between soft review and hard review. Others of you may be familiar with the debate over judicial review of constitutional amendments. Soft review is review of legislation that the legislature can in some way override or set aside. Hard review is not subject to set aside. And of course, even harder than hard review, if we were to put both forms of review on the same spectrum, which we can and should, would be review of constitutional amendments. And in fact, we can flesh out this entire spectrum that goes from no review to soft review of the Commonwealth variety to hard review of the kind that we see, for example, in the US, to amendment review, which can be further broken down into procedural and substantive review. But beyond even substantive judge-made review of constitutional amendments, there's an even further point on the spectrum, and that is when courts demand successfully that the Constitution be formally amended, and they even say what the amendment needs to say. When they basically dictate the content of constitutional amendments and they can successfully author and initiate constitutional amendments. That is precisely what happened in Taiwan. And by not paying closer attention to Asia, we actually miss some of the most extreme cases of judicial power, Taiwan being a case in point. Okay, so what has happened in Taiwan? There isn't really time to go through this whole rigmarole of Taiwan, but let me try to convey the essence of it. You have the KMT government, which it loses the civil war in China. It retreats to Taiwan and remains in control in Taiwan. It only controls the island of Taiwan, this regime that used to control all of China. Now, the problem is that the constitution that it adopted, this government adopted, the Republic of China Constitution, was designed to cover all of China. And the legislature contained seats for districts throughout China. However, the government now only controls the island of Taiwan. So you have all of these legislators from areas that are now under communist control. And they are supporters of the KMT regime. And the Constitutional Court allows the KMT to stay in power with the support of these holdover legislators. The Taiwanese Constitutional Court says that they can remain in office until elections can be held again in areas that are in a temporary state of emergency, meaning they're temporarily under communist control. Right? This is interpretation number 31, decided in 1954. Now, of course, this is a total fiction, right? Even by this time, it's pretty clear, and it only becomes clear over time, that the ROC government, the KMT, will never retake mainland China. And so this decision is basically carte blanche for the government to continue ruling, as the KMT to rule Taiwan as long as it wants, with the support of these legislators from districts that can't hold elections, basically ever again. Okay, so eventually democratization rolls around in the 1980s, and 1987 or so, and the question is, what can be done to democratize, right? So one obvious problem is you have these legislators who were elected only once in the late 1940s, and they dominate the National Assembly, which is the constituent assembly that amends the Constitution. They also dominate the legislative yuan, which is the normal legislature. And so what the Taiwanese Constitutional Court says in interpretation number 261 in 1990, this is a huge decision. It doesn't just reverse itself. And not only does it say that these holdover representatives have to leave office, it also says that new elections need to be held. And moreover, it says that the solution here is to have more at-large districts that elect legislators. Now, the problem with that decision, which would result in a truly elected legislature, is that it goes against the ROC Constitution and it cannot be implemented without a constitutional amendment. And so what does the Taiwanese Constitutional Court do? It basically instructs the government, you have to amend the Constitution and here's how you have to do it, right? So that's the Taiwanese Constitutional Court forcing the government to adopt an amendment so that there can be these new elections with more seats that are elected just by people in Taiwan, which is precisely what happens. And that's not the end of it. The National Assembly, in this process of democratization, passing all these amendments, decides to pass an amendment, the Fifth Amendment, extending its own term by a little over 2 years. Now, remember, this is still the National Assembly that is full of people who were elected only once in the 1940s, right? So this is an example of self-dealing by a constituent assembly. Now, what can a constitutional court do to prevent self-dealing by a constituent assembly? It's a very difficult problem. The problem here is that the constitutional court's tool is the Constitution, but the constituent assembly has the power to amend the Constitution. So how can you use the Constitution to police or control a body that has the power to amend the Constitution in its own favor? So that was the dilemma the Taiwanese Constitutional Court faced. And in interpretation number 499, a very famous interpretation issued in 2000, the court strikes down this Fifth Amendment, this constitutional amendment that would have allowed the National Assembly to stay in power. And it does so on a combination of both substantive and procedural grounds, right? So there have been two problems in Taiwanese democratization that have corresponded to two great leaps forward in Taiwanese judicial power. The first was this problem of the never-ending Congress, this Congress that was full of representatives who had been elected only once and remained in office indefinitely, and also this problem of the Congress that was not only never-ending, but self-dealing. It was willing to amend the Constitution to extend its own term. And so the solution here was the solution to the holdover legislators. The Constitution was going to have to be amended. That is precisely what the government ended up doing. The court said the central government shall make an appropriate plan in accordance with this interpretation to have an election of national representatives with a certain number of representatives at large, and that required amendment of the Constitution, which is precisely what the government did. Again, the second problem, how can a court use the Constitution to stop self-dealing by a constituent assembly if the constituent assembly has the power to rewrite the Constitution? And that's what the court did in number 499. It struck down the constitutional amendment as inconsistent with the fundamental nature of governing norms. And it gave itself the power to strike down an amendment. Now, interestingly enough, this was not an exercise of the basic structure doctrine that some people may be familiar with. Here, the court was not trying to defend an existing constitutional structure. It was trying to ensure that the constitutional structure could be transformed. And so this was actually a more radical step than what you see in a country like India and in other countries that have some form of the basic structure doctrine, where courts strike down amendments that are inconsistent with the basic structure of the Constitution. Here, instead, the court was demanding that radical changes be made in the name of democratic norms, which actually weren't yet in the Taiwanese Constitution. So that's a very lightning tour of a very long, convoluted, extraordinarily interesting constitutional history in Taiwan's part. But I hope that it highlights the need to study Asia, the standard repertory of courts with extensive judicial power in the comparative constitutional law literature generally doesn't include Taiwan, and that's unfortunate. It should clearly be on the map. And as I think Professor Chen and Dr. Malagodi are going to show, two other places that should definitely be on the comparative constitutional map, but are not. They are such rich intellectual areas of intellectual inquiry for comparative constitutional law are mainland China and Nepal. All right. So with that, I will hand it over to Professor Chen, and then we'll talk about his chapter about constitutions and constitutionalism in China before turning to Dr. Malagodi for her talk on constitutional history and constitutional migration in Nepal. And my apologies if I'm losing my voice a bit. Tomorrow, I am actually moving. So it's been a very, very long day, but I'm delighted that you can be here with us. And I'm very grateful to Albert and Mara for joining. And with that, Albert, the floor is yours.
Thank you. Thank you, David. Actually, it's David's idea that we have this webinar book talk. And so I thank David for inviting me to be one of the speakers. I'm one of the contributors to this very interesting and exciting book project. David didn't have time actually to introduce the full table of contents of the book, but I'm sure you members of the audience will find it most interesting because it deals with all major topics in the study of constitutional law, but it uses examples of how these topics actually operate from different countries. So it's all the examples are from different countries all over the world. As David said, there's a wide range of variation or diversity in constitutional systems and practices around the world. So the chapter which I wrote for this book project is on China and also on the topic of constitution and constitutionalism. So let me first share the screen for the PowerPoint. So I hope you can now all see the screen. So this is, you see the topic of my chapter. And you can see here on this slide an overview of the main sections of the chapter. So the chapter begins by introducing readers to the ideas of constitutions and constitutionalism. It's pointed out that constitutions and constitutionalism originated in the Western world, in Western Europe, in Europe and North America in the late 18th century. So the original idea of constitutions and of constitutionalism is that states should have constitutions that constrain the power of the government and protect the rights of citizens. So basically it's to prevent tyranny, to prevent the abuse of power. This is still the dominant theme of the constitutional law of countries which practice liberal constitutional democracy. But as we know, there are many countries in the world today which are not liberal constitutional democracies. So how do we study their constitution and constitutional law from the point of view of comparative constitutional law? So we see that these countries, in the non-Western world, adopted constitutions in the 19th century and particularly after World War II. So there are different waves of constitutional making in the non-Western world. But no matter whether you look at the 19th century constitutional making or the post-war constitutional making in Asia and Africa, you'll see that in many cases, the constitutions were not made for the purpose of fulfilling the liberal and democratic ideals that the early constitutions in the Western world were designed to achieve. For example, in the post-war world, in Asia and Africa, the constitutions were made to proclaim the independence of newly established states and their liberation from colonial rule. The constitutions served as symbols of nationhood and the unity and collective identity of the people in the newly created states. So, so in many cases, they were not influenced by ideals of liberalism. So actually, constitutions in the contemporary world serve a wide variety of functions. The traditional function, as I've already said, is of course to constrain state power and to protect citizens' rights. But there is actually a body of scholarship, a fairly big body of scholarship, which shows that constitutions also perform many other important functions, such as legitimation, coordination, safeguarding the interests of political elites, articulating the values, goals, and identity of the state, and so on. So if we take into account the wide variety of the functions of a constitution, we may need to have a more flexible or a broader definition of constitutionalism. So the constitutionalism is not just about constraining state power and protecting citizen rights. Maybe there can be other definitions or perspectives on constitutionalism. So in the chapter, in fact, this part of the chapter also contains many of David's ideas about constitutionalism. So we can look at constitutionalism from a normative perspective or even from a descriptive perspective. So constitutionalism may be used as a concept to describe the actual constitutional ideas and practices in a particular country. And for the normative definition of constitutionalism, we can distinguish between strict normative definitions and thin normative definitions. So what do we mean by thick and thin versions of constitutionalism? Actually, some of you may know that for the rule of law, there are also thin and thick versions of the rule of law. So constitutionalism can be understood similarly. The thick definition of constitutionalism would impose more requirements on the constitution, such as effective protection of citizen rights or free and fair elections between different political parties. But the thin version of constitutionalism would just require the state to be committed to being governed in accordance with the rules and principles in the Constitution. And these rules and principles in the Constitution do not necessarily reflect liberal democratic values, but this thin definition of constitutionalism would say that so long as the government is committed and actually operates on the basis of what is said in the Constitution, then the thin definition is satisfied. So now we move to the case of China. Here I set out the various constitutions in modern Chinese history. Here the slide mainly is about the PRC constitutions, and you can see that basically 4 constitutions existed in the history of the PRC so far. The current constitution, made in 1982, have been amended several times, the last amendment taking place in 2018. The Chinese constitutional system has been much influenced by the change in its political system from the original totalitarian system under Maoist rule to what we call a kind of authoritarian political system since the era of reform and opening that began in the late 1970s. We all know that the most important institution of the constitution in China is the People's Congress system. led by the National People's Congress, the so-called supreme organ of state power. The People's Congresses are elected. Lower level people congresses are directly elected, and higher level congresses are elected by the members of the lower level people's congresses. But as we know, the candidates for elections are in most cases determined by the organs of the Chinese Communist Party. We don't have the kind of Western style multi-party election in China. As regards the operation of the constitutional system, the main feature is that the constitution is implemented by legislation and not by adjudication or by the courts. As in other countries, the courts interpret the constitution and strike down laws that are inconsistent with the constitution. So that is not the way the constitution is implemented in China. The court system has developed very rapidly in the area of reform and opening, and there is a huge caseload taken on by the courts, and the judges are increasingly professionalized. But as we know, there are also problems of corruption and political interference in judicial decision-making in China. And as I've already said, the courts do not actually play a role in enforcing the constitution. Nevertheless, in the first decade of the 21st century, there were what scholars called constitutional entrepreneurs who tried to mobilize public opinion and influence policy developments by referring to and invoking the norms in the text of the Chinese constitution. This may be called a kind of popular constitutionalism, but this was only a temporary phenomenon. This kind of constitutionalism, which was quite prominent in the first decade of the 21st century, no longer continued in the second decade with Mr. Xi Jinping coming to power. There's a new mode of understanding the constitution. The constitution is still very much relied on by the government and the regime. For example, in 2015, the NPC Standing Committee passed a decision to require senior officials to take an oath to abide by the constitution. And this requirement was actually written into the constitution itself when the constitution was amended in 2018. And here you can see these photos of people taking the oath of allegiance in the constitution. So the constitution is still being taken seriously. Professor David Law has written an article in which he said that the Chinese constitution may serve as a kind of constructive irritant in the sense that it cannot easily be expelled from the system, but instead creates space for a normatively privileged form of discourse that cannot easily be ignored. A leading or a very significant feature of the Chinese constitutional system, which makes it rather unique or makes it very different from constitutional systems elsewhere, is the coexistence of the party, the Chinese Communist Party as the ruling party, and the institutions of the state, like the People's Congresses. Scholars have pointed out that this is actually a kind of dual constitution, with the Constitution of the People's Republic of China existing side by side with the Constitution or the Charter of the Chinese Communist Party. So the operation of the Chinese Communist Party is actually governed by its own constitution, which is called a charter. So maybe we can say that there is a kind of dual constitution with the constitution and the laws of the state existing side by side with the charter or constitution of the party and the internal rules and regulations of the party, the so-called intra-party regulations. So I will not go into details such as overlapping membership of the leadership of the state and party organs and other ways in which the party and the state are integrated into one another. Finally, I'll say a few words about constitutionalism in China. Is there constitutionalism in China? This depends on how we understand or define constitutionalism. For example, there is a school of thought known as political constitutionalism, which can be contrasted with judicial constitutionalism. So China certainly doesn't have judicial constitutionalism. It may have a version of political constitutionalism in the sense that the constitution is enforced by political bodies and not by judicial bodies. In recent years, scholars have also put forward other theories to explain or to prescribe what kind of constitutionalism China has or should have. So one theory is that advocated by Professor Larry Becker of Pennsylvania State University, the theory of state party constitutionalism, which basically suggests that China is actually practicing some kind of constitutionalism, which is called state party constitutionalism, because it promotes the rule of law and has some form of separation of powers between the party organs and the state organs. Then there's the other scholars in China itself, which advocate theories of socialist constitutionalism, such as the theory advocated by Tong Zhiwei of the East China University of Political Science and Law, and the theory of party leadership, constitutional party leadership, advocated by Professor Ke Huaqing of the China University of Political Science and Law in Beijing. So because time is running out, I will not tell you about what exactly are these theories. If we have time, we can deal with them in the discussion period. So my conclusion is that China is probably moving towards some kind of socialist constitutionalism or constitutional party leadership, as evidenced by the amendment of the Constitution in 2018, which writes into Article 1 of the Constitution the principle of party leadership, and also the rapid development of intra-party regulations and rules as promoted by President Xi Jinping. So given the time constraint, I will finish here. You're welcome to ask questions. I hope we still have a few minutes for questions. Thank you.
Thank you so much, Albert, for your time discipline. And we definitely will reserve some time for questions and answers at the end. And with that, it's a little strange to be the speaker and the host here, but I'd like to introduce the one and only, the incredible, Mara Malagodi, who is, as of now, at Chinese University of Hong Kong. I don't want to spill the beans, but I believe you'll be moving on to something, moving onward and upward, as they say. I'll leave it to you how little or how much you'd like to say about that. But above all, you're going to be talking about your terrific chapter on constitutional history, the complex interplay between constitutional history and constitutional migration in Nepal, and along with it, the interplay or tension between constitutional law and international law. And along the way there, I believe we'll be hearing a bit about the issues of religious conservatism and women's rights in the context of Nepal. So there's a lot going on in this chapter. Professor Malagodi.
Thank you so much, David, for including me in this wonderful project. and to HKU for hosting today's seminar and also the first conference that brought all of us together back in 2017. That feels like a very long time ago. It is such a pleasure to be here and to celebrate this wonderful book. And I have to say, the best cover ever, David. Well done. So today I would like to talk a little bit about my chapter on Nepal and constitutional borrowing and migration, to reflect on some innovative aspects of this project of constitutionalism in context, and to use that as a springboard to think about some of the developments in the field of comparative constitutional law as a whole. So the first thing that I wanted to say, that I think it's super exciting for us here sitting in Hong Kong, and I think that's reflected in a lot of the work that all of us have done over the years, is the focus that the book has on so-called non-standard jurisdictions. And I think even that choice, which is David's editorial choice, really contributes to a meaningful inclusion in the field of constitutional experiences that have been previously marginalized. And I think this move beyond the canon, in a way, is in itself important because it contributes to changing the directionality of borrowing in constitutional making and adjudication. And I think the intellectual focus of the book is really reflecting changes in practice as well, in terms of regional forms of borrowing that we've seen, for instance, in South Asia for a very long time. And that there is a tendency, I think now, to look much more closely at home and in neighboring jurisdictions. I think it's also encouraging a shift in the emphasis on which experiences offer meaningful and valuable lessons for other jurisdictions to take on board. And there is so much more that we can learn, and I agree with you, and I hope to show a few interesting developments taking place in Nepal. And ultimately, I think epistemologically, there is a lot of value in a project like this, because it really helps to decolonize the subject of comparative constitutional law, which has really been incredibly Eurocentric, even if I think in the last 10 years or so, we're really seeing amazing changes taking place. So let me turn on now to my chapter. So my chapter on Nepal for constitutionalism in context follows in the footstep of the framework that David set for us and engages with the tension between constitutional autochthony, which is the term that in a way I almost prefer to constitutional history, because I think it's more precise in what I'm trying to depict and engage with, and constitutional borrowing. And ultimately, this is really a tension between the construction of local and global constitutional norms, and to see how they play out, especially in the making of the 2015 Constitution of Nepal. And I think some of the examples that I'm going to draw on today are specifically with respect to gender constitutionalism and sexuality. So why Nepal, and why is it so interesting to explore these kind of questions? So I think Nepal in a way is an ideal case study, because we're looking at a jurisdiction, a country that was never colonized, which is one of the few in Asia. And so in a way, it kind of sets us up to think about an ideal case study for, in a way, perhaps constitutional originalism and forms of constitutional norms that we would expect to be quintessentially local. But what about this constitution? Why is it so interesting per se? So when we look at the 2015 Constitution of Nepal, it's the 7th in the country's history. It's a post-conflict document, and there was huge expectations placed on that. The idea was that this new document would have really developed and delivered forms of social inclusion through state restructuring. So of course, it was drafted by a constituent assembly, actually technically two, with extensive international assistance in a period of 7 years between 2008 and 2015. So as I said, this document and the focus on gender and sexuality really becomes a prism to assess tensions between constitutional autochthony, and by that I mean local constitutional authorship and content and also the unique definition of national identity. This element of constitutional autonomy really underpins the claim that modern constitutions really fulfill the function of engendering and reinforcing a sense of national ownership. So on the one hand, we have constitutional autonomy. On the other hand, we have the inevitable dynamics of constitutional borrowing. And by that, I mean the use of transnational material in constitution making and constitutional adjudication. So constitutional borrowing in itself is underpinned by the claim that there is always a degree of compliance with international standards, but also that comparative constitutional law as an intellectual exercise and as a practice exercise is really steeped now in forms of cross-pollination, that it's impossible to make a constitution from scratch. No one is reinventing the wheel. So if we're looking at distinctions, what do we see? Let me give you two examples from the text of the Constitution of Nepal that I think kind of help us engage further in this discussion. So on the one hand, we have constitutionally recognized forms of gender-based discrimination against Nepali women in passing on their citizenship entitlements to foreign spouses and to children conceived with foreign spouses. So to quote David at a conference we both attended many years ago in Nepal, this is unusual for constitutions which have been made so recently and with so much international assistance. It's clearly a breach of international law. And statistically, again, quoting David, the likelihood of seeing something like this is perhaps in Saudi Arabia, right, in recent constitutions. So I think that was also part of his own quantitative analysis looking at something like this. On the other hand, the same document, when we're looking at gender, explicitly recognizes women's rights and the rights of gender and sexual minorities. And especially with respect to gender and sexual minorities, a minuscule amount of constitutions around the world contain this kind of provision. So what does it mean? And of course, we would have to talk about implementations and so on. Unfortunately, I don't have the time and space to do that today, but I think it's interesting to see, even just through the prism of gender constitutionalism, to see how such diverging set of provisions can feature in the same recent constitutional text in a document which is being made so recently. So one of the elements that I talk about in my chapter is the United Nations Constitutional Assistance Guidance Note of the Secretary General, which was initially issued in 2009 and it's been recently revised in 2020. So there is a tension already in the 6 points that the note recommend between ensuring national ownership and reflecting the local context, together with promoting international norms and standards. And that is really recognized also by international constitutional system at the highest level at the United Nations. So how do we end up with something like this? And of course, I could tell you a very complicated story of constitution making and so on. But I think what I wanted to conclude specifically with respect to the Nepal experience is that, of course, if you do, and as I did interviews already with the constitution makers of the 1919 document for my doctoral project, it's the similar story of what I was told with respect to the 2015 constitution, that gender-based forms of discrimination in matters of citizenship reflect the specific local context of Nepal, the precarious geopolitical position of a relatively small country sandwiched between India and China with an open border with China. And the idea is that, well, these kind of citizenship provisions are designed to maintain that autonomy. But then, when we're talking about this kind of constitutional specificity, this kind of constitutional history, then the question we really should ask is whose history? Whose groups are protected or empowered by these kind of mechanisms? So I think the focus on constitutional autonomy really, especially also by international actors assisting, they tend to kind of look at constitutional autonomy through the prism presented by the dominant groups. So it's not the history of the entire population of a jurisdiction of a country. It's the history of the dominant groups that is usually reflected in those forms of constitutional autonomy, and gender in certain forms really becomes a victim of all of that. As I said, it's a clear violation of international standards, which is puzzling for a constitution which is made as late as 2015. And in a way, what seems to me is that compliance to international standards is somehow subordinated to questions of national ownership. And it seems to me that this tension ends up reinforcing patterns of hegemony, which have long developed historically. So I think, there is much more unpacking. And I think here, let me zoom out of the Nepal case studies and kind of come back to some of the themes to conclude, since we're also short of time. So when we're looking at this question of compliance with international standards and question of borrowing here, what is it that then becomes significant when we look at questions of identity politics and constitution making? I think what we want to consider here in terms of some of the bigger questions with respect to constitution making is perhaps to challenge this idea that some of the state actors and some of the dominant groups are uniform actors, that a little bit of deconstructions and historically informed reading would go a long way. When we're looking at constitutional borrowing as well, I think, there is a particular repertoire that we're considering, and it is a particular repertoire that is steeped in the constitutional histories of the jurisdictions that are taken as models. So the epistemological shift in the discipline hopefully will lead to changes at that level as well. And the last point really that I wanted to make with respect to this is really the importance of looking at Asia from a broader perspective and kind of bring that into the mainstream. So I wanted on this note to thank David and to thank Albert for all these meaningful discussions and for how much they've enriched all of us. So thank you so much. I know we're short of time. I'm going to conclude here and I look forward to the Q&A. Thank you.
Thank you so much. And the floor is open if anyone has any questions about the book. But I also wanted to take a moment to thank Mara for reminding me about the cover. If you look behind me, the background here is the cover for the book. It's based on this famous Howard Chandler Christie painting, the scene of the signing of the US Constitution. And instead of the framers of the US Constitution, each and every figure except for one, James Madison, has been replaced by at least one representative from each of the countries in the book. And the result, Dr. Malagodi was extremely helpful in giving a lot of artistic feedback on the cover here. So she kind of is a co-owner of this cover here. If you're interested in constitutional law trivia, you can be looking around behind me and see how many of these people that you can actually name. Most of them are historical or actual figures, but not all of them. And one consequence of the representativeness of the book is that you have a cover that, for example, is half of the people in the half of the figures represented are Asian, a quarter are Black, a quarter are white, and that's actually demographically about right if you look at global population. And I believe the geographic representation is there as well, as is the gender and religious diversity. So if that painting done of an event, a 20th century imagining of a 19th century gathering had been representative of the world's diversity rather than being composed entirely of white men, this is sort of what the room would look like. Let's see. So any questions from the audience?
I think the questions can only be posted in the chat box.
Oh, yes, that's right. Yes, we have this Q&A box. Let me just try to bring it up on my screen. There are some, but I cannot see them. Oh, here we are. Got this tiny little screen. Yes, okay. We have a, let me read out these questions. They're quite extensive and thoughtful. The first set of questions is from Changbu. His first question is related to judicial power. He notes that a constitution stipulates not only individual rights, but the configuration of the state apparatus, and constitutional disputes accordingly can be divided into rights issues and megapolitics issues. To his understanding, I'll just read this. To my understanding, the strongest justification for judicial activism is based on the need to protect individual rights. Yet now we see judicial activism in resolving issues of megapolitics that may not necessarily involve rights issues. How do we understand the legitimacy of this type of judicial empowerment within the Asian context? Interesting. So the judicialization of megapolitics in the Asian context, how do we understand its legitimacy? The second question he has is about the conceptual understanding of constitutionalism, a focus of Professor Chen's chapter. If we go beyond liberal constitutionalism, how do we reconcile the empowering aspect of the Constitution and the power limiting aspect of a liberal constitution? How do we strike a balance or draw a boundary between the empowering and power limiting facets to realize constitutionalism as opposed to totalitarianism or absolutism? Okay, so that's quite a tall order. Albert, would you like to take a swing at the question about the conceptual understanding of constitutional, or either or both? And then Mara, why don't we turn it over to you, and I'll take a shot after that, if either of you would like to jump in. And then we have two more questions from our distinguished colleague, Jed Kroenke, as well, waiting in the wings.
Yes. So I'll answer the second question. I think, David, would you like to answer the first question in a minute? The first
Sure,
question,
I'll let you go first, yes.
Yeah. So the second question, constitutionalism and its role in protecting rights on the one hand, and also its empowering function on the other hand. My own view is that the emphasis on limitation of state power and protection of rights is the original feature of constitutionalism and constitutions as it first developed in Europe and North America. But as the globalization of constitutions and constitutionalism took place, there are other countries which place less emphasis on these original functions of the Constitution. So, for example, in the case of China, there is now increasing reliance on the legitimacy. So, increasing reliance on the Constitution as a source of legitimacy of the regime. For example, the Constitution, Article 1, as amended in 218, states the leadership of the Chinese Communist Party. So when you take the oath of allegiance to the Constitution, people are also taking an oath of allegiance to Article 1, which prescribes the leadership of the Communist Party. But this may still be within the thin version of constitutionalism, because the thin version, as I already said, that means that the Constitution is taken seriously, the regime takes it seriously, and tries to operate in accordance with what is said in the Constitution itself. So I think the question of your question of drawing the boundaries, actually a question of whether the question of how much weight is put on the liberal objectives of constitutionalism or constitutions versus how much weight is put on the other non-liberal functions of the Constitution. So in every country, maybe there is a different balance of the weight to be put on these different elements or values in the Constitution or constitutionalism. That's all. That's what I want to say. Yeah, thank you.
Mara, you want to take a shot at either of those?
Sure. I wanted to say a few things about judicial activism. So if I answer this question from a South Asia perspective, So I think what you see as being quite interesting already at the moment of constitution making, what the judiciary and the way in which the judiciary was framed under the Indian constitution, the judiciary and especially the Supreme Court really began to acquire a particular symbolism as well already at the time of independence as a sign of decolonization. So the judiciary within the constitutional framework in India really became the emblem of what that was. And also it's an example, looking at South Asia, of constitutional borrowing across neighboring jurisdictions. So if we look at forms of judicial activism, the kind of remedies which are used by the top courts across South Asia, it's an example of some of the developments that took place in India under very specific contexts, and they then kind of traveled throughout from that point of view. Whether it's a question of megapolitics. So I was reading the work of the historian of the making of the Indian Constitution, Miti Mukherjee at the University of Colorado, who makes a super interesting set of claims with respect to that. So I highly recommend her work from that point of view. But it's also the idea that it has to do with the kind of conception of power and sovereignty and the continuities with colonial rule that we see this kind of development. So it's a mix of continuities and breaks from that respect. Also, I think what you see there, it's also an example of the judges, and I think in the Nepal context, having done interviews with a number of them, that it's the idea that they're picking up the baton and basically filling the gaps of what the executive and what the legislature does not do. So in a way, they see their role as kind of complementing what the other branches do not succeed in doing, rather than kind of encroaching. And I think that's an interesting perspective. Thank you.
Yeah, I'll take a quick stab at the question about megapolitics, judicialization of megapolitics, and how we should understand its legitimacy in the Asian context. As a threshold issue, I think one reason that we should be studying Asia more is because constitutional phenomena are generally not Asia specific, right? And I think that the rest of the world makes a mistake in not studying Asia, because a lot of what's going on in Asia can and should be generalized to the rest of the world, and vice versa. So I'm on the side of the people who are slightly skeptical of the idea. This is a bit ironic for me to be saying this, a bit skeptical of the idea of Asian constitutionalism as a unit of analysis, right? Really, it should be on an equal footing with other units. For example, when it comes to the judicialization of megapolitics, it is true that the defense of individual rights, there are a lot of liberal justifications for courts to be very active when it comes to the defense of individual rights. But I think what we are also seeing in Asia and elsewhere is that courts are also willing to intervene in megapolitics when it comes to questions of regime change or regime preservation. Cases in point, the review of constitutional amendments that are said to threaten the basic structure or the basic constitutional order. We see courts around the world, in Taiwan, as we just saw, as well as elsewhere. They're prepared to wade into megapolitics and wield a lot of judicial power when the question is one of regime change or regime preservation. Regime preservation when there are attempts to fight off transformative amendments, and regime change in the context of democratization. So I think we have at least three settings where courts feel that it is, courts generally, not just in Asia, feel that it's appropriate for them to wade into megapolitics. One is the defense of rights, particularly defense of minorities, because they can't rely on the democratic process. We're all familiar with that story. But also when the survival or transformation of the regime itself is at stake, right? If they're not going to get involved then when will they get involved? There, the stakes are big enough that they really have no choice but to do something. They feel, what we're seeing is courts feel that it is worth their while, worth the risk to their reputation or legitimacy to wade into those kinds of disputes. Great. Okay, so let's take on the Professor Cronky's questions. Two potential questions. First, what is the most prominent current, perhaps the most prominent current representation intervention in comparative constitutional law's inclusion of the global south? Yes. How do you see this project overlapping or not with this Asian representation? Many of the Asian jurisdictions in the project are commonly included in the Global South, but many are not, or majority perspectives in these jurisdictions openly reject being so categorized. Fair question. Second question, we are in an era of pessimism about the pro-social potential of judicial review growing to match the level of optimism about judicial review, which gave birth to the modern comparative common law wave of the 1990s. Well put. Both in terms of the liberal model internationally, but also within many liberal democracies themselves, no less dramatically than in the United States. Does Asian representation add to or moderate this trend, or is it not a relevant question to have to derive specific impacts to justify Asian representation? Well, a lot of food for thought there. Mara, Albert, anyone like to take a shot at those, and I'll jump in?
Okay, maybe I'll say a few words on the question of Asian representation. I think study of Asian constitutions and constitutionalism is overlap, but differs from the study of the Global South, because we have certain jurisdictions in Asia which are definitely not part of the Global South, like Japan and South Korea and probably even Taiwan and Singapore. So even though Singapore is close to the South, I don't think it's part of Global South. So, but there are very interesting constitutional developments in these jurisdictions. Actually, as David points out, the study of Asia also is a study of diversity, in constitutional ideas and practices. Just focus on what the three cases we discussed today. They are also very, very different from one another: Taiwan, mainland China, and Nepal. As for judicial activism, judicial review, and the Asian contribution, I think we have constitutional courts in Asia. I think we know that there are at least 7 constitutional courts in East and Southeast Asia. I have co-edited a book about constitutional courts in Asia. So the study of what these constitutional courts do, or what the development or the trends, is also a very useful contribution to the study of judicial review generally. And we should not, of course, there are well-known constitutional courts like South Korea's and Taiwan's. Professor Yap Po-Jen, who is here today, has co-authored a book about these constitutional courts. But then the newer constitutional courts, like those in Thailand, which is actually, or once is extremely activist. And you have also got constitutional courts in new democracies like Indonesia. And then the Philippine Supreme Court was also activist at points of regime change and so on. So I think these Asian cases, not to mention India and Pakistan and Sri Lanka, do make important contributions to the study of judicial review. Thank you.
Mara, do you want to chime in?
Do you want to go first? Because I see there is a question specifically for me.
Oh, yes, there is a question for you as well. Okay. I would concur with what Albert said about the Global South and Asian representation. These are overlapping sets, but they're not identical sets. I will say one of the things that's striking to me is that even the parts of Asia that are not the Global South, Hong Kong is not the Global South by any stretch of the imagination, they're still underrepresented in literature. And Hong Kong is a puzzling case because here you have a jurisdiction, there's no language barrier for English-speaking scholars to study it. It's clearly economically very advanced. It's a place that a lot of scholars are exposed to on a firsthand basis, and yet it's so widely overlooked, right? And so I think one of the reasons that a lot of us wanted a book like this, and ultimately we decided if we wanted such a book, we'd have to build it ourselves, was the underrepresentation of Asia for no obvious reason, right? You could say, well, the Philippines isn't represented, for example, because it is part of the Global South and it's not as economically advanced, but it also has very active constitutional politics. It's a liberal democracy, active judicial review, and it's accessible in English. So a lot of the boxes, a lot of the things that we think lead people to focus on particular countries, there are countries in Asia that satisfy these requirements, and yet they're not very well represented, right? In terms of the pro-social potential of judicial review, I think that and Professor Yap actually has written on this as well. The role that judicial review has played in judicial review is kind of inherently weak medicine, is my own view. I mean, if you look at, for example, all this literature on constitutional backsliding in Latin America, right, and courts trying to resist the transition to authoritarianism, and yet there's really only been one court in Latin America that successfully resisted on the question of term limits and presidents and strongman rulers entrenching themselves, and that's been Colombia, right? So I don't think the record in judicial review, there are good reasons to doubt how much it can do. I don't think the record of judicial review in Asia, its ability to have pro-social effects, has been any worse. It's maybe even been a little bit better. I think generally speaking, people give the courts in South Korea and Taiwan a lot of credit, rightly or wrongly. They get a lot of credit for helping to facilitate and stabilize democratic transitions in both of those countries. And, you know, these days, a stable, consolidated democracy is nothing to sneeze at, right? So it's one of those things that seems to maybe not have huge pro-social effects that often, but it's worked, I would say, at least as often in Asia as elsewhere. Yeah, that would be my take on that. And we have one last question from Ivy Liu, and it is a question for Dr. Malagodi. She writes, it is recognized that the Nepali Supreme Court has played a proactive role in the constitution-making process. How would you evaluate the role played by the court? Has it contributed to the democratization process in Nepal, or has it had instead negative influence, real or potential? Thank you.
Thank you so much. That's a wonderful question, really insightful. I would say that it's interesting. So even if you just look at the text of the Constitution, you see that a lot of the previous judgment of the Supreme Court, gender is a great example of that, have been in a way translated into the constitutional text itself. On the other hand, I think the Supreme Court of Nepal has been so prolific. And I think if we're looking at the way in which it has really intervened kind of hands-on in a lot of the key aspects of constitutional life in the country, I think the executive has felt quite threatened. And so if you look at the results in the 2015 Constitution, there has been an attempt at downsizing the role of the court. So for instance, the creation of a constitutional bench within the Supreme Court, which is the only part of the court which is able to essentially judicially review legislation, has really increased the backlog of the court and kind of limited the scope of public interest litigation, which is the mechanism through which a lot of the cases come to the court. So there has been, in a way, quite a conscious attempt to reduce the scope of the court, also in the way in which the impeachment proceedings have been made easier. And that's resulted in already 3 attempts since the new constitution has been passed. I think the Supreme Court of Nepal has contributed enormously to the developments, for instance, in gender constitution. I think in other areas much more uneven. So if we're looking at the treatment of ethno-linguistic minorities, of lower caste Nepalis, I think the record is not quite so straightforward when we're looking at questions of inclusion. When we're looking at question of democratization more broadly, I think if you look at the saga of the Supreme Court intervention in the dissolution of the first Constituent Assembly cases, we're looking at a much more problematic record where there have been allegations of the Supreme Court being partisan with respect to that. So I think it's a mixed record. I'm much more positive when I look at gender constitutionalism in terms of record. When we look at democratization, I think there are lots of caveats. Thank you so much. Excellent question.
Well, I want to thank everyone in the morning in Hong Kong time or very late at night here in the US East Coast and all points in between for joining us for another Zoom, for not being zoomed out, and for giving us a chance to share with you some slices of constitutionalism and context. There's one last thing I would like to share with you, and that is hopefully there will be a more affordable version of this soon, but there is a 20% discount on the book. There's the cover with that illustration, which took a lot of research assistants and a lot of artists, a lot of time to produce. But if you're interested in that, you can reach out to any of us for that discount flyer. And our hope is, the good news I'd like to say, I don't know how my editor would feel about this, but the book is doing well enough that we should see a paperback reasonably soon. But in the meantime, if you order directly from CUP, this book was always meant to be an affordable edition that was within reach for graduate students. It was meant to come out as a paperback. The pandemic has had a lot of effects on the academic publishing industry. We're grateful the book is out. We're grateful that it will have a second life as well. But at least in the interim, we realize that the book is for a book written for an Asian and global South audience, the price point is really not where it should be. But we're hopeful that that will improve over time. And in the meantime, any change that anyone can save on the book, I hope is a little bit welcome. So this concludes our Asia-focused panel on sort of a homecoming of sorts, a self-hosted homecoming to the University of Hong Kong and the Center for Comparative Public Law, my home for many years, a wonderful place. I'd like to thank the director, Professor Yap, if he's still listening there. And I hope to see many of you at either Icon S and or Law and Society. I know that Dr. Malagodi may hopefully be joining us at least one of those events. And I wish everyone stays safe and well in these challenging times, and hopefully better times lie ahead. But in the meantime, for a global perspective on these crises, I'm really glad that you all joined us for this conversation. And everyone stay well. Thank you.
Thank you and goodbye.
Thank you so much.